Real water deserves to be made an example of. Mr. Kemp gave you several reasons why. To me, in addition to all the reasons that Mr. Kemp gave you, what happens if you don't make an example of real water?
Let me move on to Jasmine and Tina and Mrs. Brody. Jasmine sitting over there. You heard her story. She was 29 years old at the time. She suffered for over a month. A month of suffering that didn't have to happen if they had done a recall, okay? She suffered for over a month. First she went to the quick care, then she went to the hospital, diagnosed with acute liver failure on November 15th, 2020. And she was really suffering before she went to the hospital. Vomiting blood almost every day. Here's Shane, put up the hospital slide. They reported in the medical records, okay, vomiting. The symptoms started in the middle of October, right when they should have done the recall. Next one, Shane. Move back. Got so bad, she started vomiting twice a day. Twice a day she's vomiting. Okay, and this was her testimony, you heard it.
And what happened next after that? As the days or weeks kind of progressed, my symptoms kept changing. I would feel pain in my abdomen. It would radiate from the front to the back. Very, very nauseous. I would feel like mind fog. Like I felt like I really wasn't there. I would feel just tired out of nowhere, to the point where I found myself sleeping 12 hours plus a day.
And you mentioned, I think, nausea. Was there a point when you started vomiting as well?
Yes, so maybe 2 weeks after I felt I wasn't feeling well, I started vomiting, and I would vomit maybe once a day to where it came to be multiple times a day. I would see blood in my vomit, and it would just keep occurring every day.
Okay, before looking at her liver function test, let me just show you the normal again. So normal ALT 12 to 78, normal AST 15 to 27. Shane, let's see what Jasmine had. These are unbelievably high, okay? 3,637 AST, and then it went down slightly, and then we had a 486 that went up to 1,306 ALT. And let's use a little comparison here. This is what Jasmine had. Let's compare her with Myles. She had significantly higher liver function test abnormality than Myles, who had to have a liver transplant. That in and of itself tells you how sick Jasmine was. And the only difference between Jasmine and Myles is she didn't have to have a liver transplant. But they told her that she might have to have a liver transplant. Go ahead, Shane.
So, I believe you mentioned a little bit, but were you made aware of the need for a potential liver transplant?
As my statement, yes. Before I was advised of that, I was supposed to be released home. And the next day, the physician came back in the room and told me I would not be going home because my levels were very high. And she said if they don't go down, then the next potential thing that will probably happen is a liver failure. a liver replacement.
Okay, think about that for a minute. COVID is raging at this point in time. She's in a COVID-restricted hospital. She's all by herself. Her systems were completely shutting down. They were telling her she may have to have a replacement liver. She's got a brain fog. And so what happened next? They did a liver biopsy. They took out the needle, put it into Jasmine. She told you, and I'm going to play it for you, she told you about this. Go ahead, Shane.
And go ahead and tell me a little bit about the biopsy. What was that procedure?
They took me into the surgical room where I got the biopsy, and I am awake for this whole procedure. So they moved me to the table, the operating table, and they positioned me to lay on my left side to where my right side was exposed. And they took this big surgical instrument to where they had to insert it in my side to get to my liver. And when they inserted it into my side, I felt everything they did. So when they had to pop the instrument into my side, I instantly couldn't breathe. I felt when they put the second instrument to take a sample of my liver, and I felt it when they took it out. And, sorry, when they took the instrument out, I immediately couldn't breathe. I could not catch my breath. And I immediately started sweating profusely as if I jumped into a pool. And I couldn't have no control over it. And I immediately told them that I was in pain. But they told me they couldn't do anything because it would potentially harm my liver even more. So I had to suffer probably 2 more hours of that pain until they can do anything for me.
So they wouldn't give you, what I'm saying is they wouldn't give you pain medications because of the state of your liver?
Yes.
Liver biopsy with no pain medication. Now, the direct pain from the biopsy lasts about 6 weeks. Jasmine told you about it. But she's got physical and mental suffering that have lasted at least till now, probably last, who knows, longer. Go ahead, Shane, play the clip.
Based upon your experience and your education, is it your opinion that all of the plaintiffs, with the exception of the Hunwardsen court to get a liver transplant, more probably than not, will have liver scarring as a result of consuming hydrogen?
Yes.
And as a result, all of them will need future monitoring for 2 years, for at least 20 years, or 3 of the 5 years for Ms. Brody, and then continuous monitoring by a transplant hepatologist from the surplus.
That is correct.
Okay.
Okay, liver scarring, what's that mean? When you pour rocket fuel on someone's liver, it scars the liver. That's what he's talking about, liver scarring. And because of this liver scarring, these livers are permanently damaged. You know, they didn't get a new one like Myles got. They have their own liver that's permanently damaged. And that's why you have to monitor it. You have to monitor it for 20 years for Tina and Jasmine, 5 years for Mrs. Brody, because she's a little older. So, now we've got to turn to compensatory damages for Jasmine. So, unlike the case of Myles, where I told you there's a lot of subjectivity, we have direct evidence in this case. We have testimony as to the value of an acute liver failure. Okay? Direct evidence, testimony that I'm going to show you in a second. Go ahead, Shane. So let's just go through what acute liver failure is. I mean, you've heard this. I started the opening. Quick medical condition, you know, take you to the ICU, makes your liver stops working, next, Shane. So serious complications, 20% of the people die. Okay, serious issue. So I said there's direct testimony or direct evidence. So let's talk about the difference between evidence and argument. Okay, evidence and argument. This is the jury instruction that the judge just read you. Jury instruction number 11. The evidence which you are to consider in this case is the testimony of witnesses, and then the other things. Statements by me, statements by Mr. Odou, that is not evidence, okay? Testimony is evidence. Remember, Lane Jones got acute liver failure. Lane Jones was told that he might have to have a liver transplant. Shane, you play that for me?
Okay, and then it says, what they didn't know was if I had gotten worse, the only option was a liver transplant, unquote. Did I read that right?
Yes.
And did they discuss a liver transplant with you?
Yeah, a specialist came in and he said that there was a short amount of time where he was debating whether or not to send me to California for a liver transplant.
So Lane Jones, the executive vice president of Real Water, had the same injury as Jasmine did. His wasn't even as serious because he didn't have a liver biopsy like Jasmine did, but he had the same, substantially the same injury, okay? And we asked him, we asked Mr. Jones, well, okay, what do you think the injury that you had was worth? Shane?
Okay, and it says, on the next sentence it says that debilitation of liver failure, I have been to hell and back. Did I read that right?
Yeah, it was a very terrible experience.
Okay. You wouldn't go through this again if I gave you $10 million, would you?
No.
That is the testimony of Real Water's vice president as to the value of an acute liver failure injury. He went through it. He said it was to hell and back. He said $10 million. And that testimony is evidence. That is the only evidence in the case. My argument, Mr. Odou's argument, that's not evidence. That is the only evidence of the case as to the value of an acute liver failure injury. So this is what the verdict form is going to look like for Jasmine, okay? So past physical and mental pain, suffering, permanent injury. Future, okay, $10 million. Mr. Jones didn't cut it up for us. So what I suggest you do is just cut it in half and put $5 million on each line. That is the figure. That totals $10 million. That's what the executive vice president of Real Water said that this injury was worth. Okay. Now let's turn to Tina. Okay. Tina was home with her husband when she got sick. Same thing, vomiting, nausea, fatigue. Let's hear Tina's testimony first.
And so after you can see what happened.
I didn't really finish the suit.
Okay.
I told him I was still sick. And he's like, well, man, go to the bathroom. I'm like, I can't walk. He's like, what do you mean? It's like, I told you I don't feel right. My head feels like a bobblehead.
And Tina had elevated ALTs, ASTs too. Next, please. AST 2121, that's basically exactly what Myles had, right? ALT, pretty close to Myles as well. Tina was counseled about the liver transplant, but Tina had one additional injury, okay? She had encephalopathy, and that caused the psychosis you heard about. These are from the medical records. She became paranoia. Remember Dr. Hudson explained this, his liver can't remove the toxins stay in the blood with the toxins go in the brain, that causes brain swelling, and that makes you paranoid. So she's in the hospital for 7 days, 7 days. And during the time period she's in the hospital, COVID restricted also, no visitors. So she thinks people are trying to kill her. She thinks they're out to get her. And so they set her up with neurology, they set her up with psychiatric care. That's really the only difference between Tina's injury and Jasmine. Tina had the psychosis. And what we suggest to you is you do the exact same thing with Tina. Can I have the verdict form, Shane? Oh, well, this is Tina's testimony about the psychosis. Go ahead, Shane.
So at the very bottom here, it notes that you were paranoid. He started walking up and down the halls and stated that people were trying to hurt you. And if we flip over to page 14, there, Shane, it notes something similar where it says that you're very paranoid, pointing at people, thinking that you and other people are trying to kill you. And I know we heard from Dr. Hudson about encephalopathy yesterday, but can you kind of tell me what you're experiencing at this time?
Pretty much what that says. I felt like I was in the twilight zone. My thoughts weren't together. I didn't trust anything, any food, any water, any person that came in my room. To me, it was all real, and it was weird.
The delusions were real.
I was walking the halls because I didn't understand why they were keeping me here in the hospital. I know where to go, and of course I got escorted back. But yeah,
And how is that feeling now looking back?
now what?
Now looking back on it.
Oh, it still hurts me. It still scares me. Because, you know, it messed with my head so much. I don't know if it was really real or what I was thinking. And it hurts.
Serious mental problem caused by real water. So this is the same verdict form. It's exactly the same for Tina as it was for Jasmine. So we suggest you do the same thing, the exact same thing. And again, 10 million figure, that's what the evidence, that's what the testimony of the Vice President of Real Water was. I know Mr. Odou is going to come in and try to get you off that figure, but that's what the evidence is. All right, next. Now we have Mrs. Brody. Mrs. Brody was 78, and then she has the attack in the beauty salon. Go ahead.
Can you tell us what's your experience?
I was in like a beauty salon having a pedicure, and all of a sudden, out of nowhere, I got this heat came over my body and my face kind of swelled and was hot, and my hands started tingling, and then I passed out, and then when I came to, one of the girls in the salon helped me to the bathroom. Everyone wondered what happened to me, and then I ended up throwing up and having diarrhea, and I just felt like I was out of control of my whole body.
Did you have abdominal pain?
Yes, I had stomach ache, and then I went to the bathroom, yes.
Had you ever experienced anything like this degree before?
Never. It was really scary. Because I couldn't figure out what was wrong. Especially when you're a little older, you're like, this is it.
Were you able to drive after this?
Oh no. They called one of my friends to pick me up. I could not drive. I couldn't function.
Did you have an altered mental state?
Yeah, I couldn't. I just didn't feel like I could even think. I couldn't think.
So her friend drives her home from the beauty salon, and 2 days later, it strikes again. Keeps drinking the real water, it strikes again. It's 2 days before Thanksgiving. Go ahead, Shane.
So let's go back to November 24th, 2018, the time that you had this event. Can you tell the jury what symptoms you were experiencing at this time?
At my house, okay. I started feeling that heat come over me, and my heart was pounding, and my hands were tingling, and then I went to the bathroom and I threw up, and I had stomach cramps, the same symptoms. I was just out of control, period. I couldn't think. I couldn't do anything because I didn't know what was going on. I was scared.
Did you feel confused or like you had an altered mental state?
Yes.
So they take her to the hospital. She goes to, I think she goes to Henderson Hospital, same one that Myles went to. Here's the narrative from the hospital. Same thing as all the plaintiffs had: vomiting, dizzy, confused. And she's been having this for 30 days. Next, please. With vertical. Oh, go ahead.
And you heard Dr. Hudson's recommendation that you get biannual liver tests to monitor for any problems that may arise in the future, correct?
Correct.
Is that something that you have an interest and commitment of doing going forward?
Yes, I would do that.
Okay, and that brings up a different damages element that Mr. Parker reminded me I skipped over. So the Jasmine and Tina and also Christina are going to have the liver monitoring for 20 years. So there's going to be a number for that. And that needs to go in Jasmine and Tina's verdict form. Mr. Parker is going to explain that to you. It should be the same number for all three of them. But Mr. Parker is going to explain that. Mrs. Brody, this is her verdict form. Mrs. Brody was 78 at the time. She's now older. And even though the only evidence is Blaine Jones is $10 million, I mean, that just, Mrs. Brody's not crazy. So what we suggest to you is you just give her $1 million and $1 million for past and future. That's what we suggest. We don't think that anything more would be appropriate. So, ladies and gentlemen, I want to thank you. Mr. Parker's going to speak to you now about Ms. Sosa. And I really sincerely want to thank you for being here and for the attention you've given. You've been on time basically every day, and it's just kind of unusual sometimes for some of the jurors. But again, I want to thank you. It's a weighty decision for you, a very weighty decision for you. These are these people's lives in your hands, and I trust you'll do what needs to be done. Thank you.
Counsel, could you all approach a medical clerk? Could you turn off the lovely white noise, please? At 11:50. During this recess, you are admonished not to talk or converse among yourselves or with anyone else on any subject for the trial, or read, watch, or listen to any report of or commentary on the trial or any person or entity connected with the trial by any medium of information, including without limitation, social media, text, tweets, newspapers, television, internet, radio. Anything I've not stated specifically is, of course, also included. Do not visit the scene or the events mentioned during the trial, undertake any research, experimentation, or investigation. Do not do any posting or communications on these social networking sites or anywhere else. Do not do any independent research, including but not limited to internet searches. Do not formally express any opinion on any subject after the trial until the case is fully and finally submitted to the time of jury deliberations. With that, have a nice break. Thank you so very much.
All right, for the jury.
Appreciate it. Everyone have a nice break. And come back and we'll ask you the question. So we're outside the presence of the jury. All counsel are present. So quick question really was kind of the scheduling question, what you all wanted to do. And as the court noted, based on the time estimates provided on Friday, my wonderful JA, proactively ordered some lunch for the jury, but since it's sandwiches, we can wait a couple of hours. The court has no preference whatsoever. Whatever you all want to do, let me just hear what you all want to do. Like I said, the court has no preference. Just let us know what you'd like to do. Thank you, Counsel. Mr. Odou, you have a few moments to think it over, so what's your position?
Thank you, Honor. Joel Odou for Will Water. We would inquire whether they could get their sandwiches and take them in the hallway and eat them, or take them downstairs and eat them. The concern is we have alternates. Obviously, they get a sandwich too. They're going to be sitting in a room with the alternates.
Like I said, the
It's
court
just
has,
difficult.
no worries. Like I said, some attorneys want it, other attorneys have concerns about it. This court has no preference whatsoever. Sandwiches can be put in the refrigerator and given to them in the afternoon when you all
Also,
conclude your
Yeah.
closing arguments, and then they can decide if they want to nosh on them later in the afternoon or not. Like I said, the court has no preference whatsoever. Sometimes people like it for different reasons, and so we offer you the option. In light of counsel for Real Water's position, do you have any objection that you're just going to continue on with the closing arguments? We'll break for lunch at the break time, and then whenever closing arguments are done and the jury goes back to deliberations, they will see a platter of sandwiches and cookies and things back there for them, whatever time that may be. Does that work for you?
That works for us.
Okay, so we're gonna bring the jury back in. You're gonna just pick a time, Mr. Parker, because you said you wanted to break up your closing so that the jury had its lunch break at whatever time. So we're gonna leave it to you, but you're just gonna say, is this a good time for lunch? I'll read the admonition, send the jury out, you come back and you can finish, and then Mr. Odou can do his, and then whatever rebuttals get done for rebuttals. Is that what you all are requesting, or are you requesting something different?
No, that's exactly what we're requesting. Thank you so much.
Exactly, Your Honor. Thank you very much.
Perfect, thanks. As a heads up, Marshall, please go get the jury. I appreciate it, thank you so very much. I can appreciate that the court does not, is hoping something comes across before we have to address verdict forms going back to the jury. The court currently does not have anything for it to review. That's not you all's issue, but I may need to see if you all are on the record going to state something before we close the closing arguments, right? Before the jury gets the proposed verdict form, to make sure that you all are all in agreement. Does everyone understand what I'm saying? Is it currently has the lines it has, your closing arguments are based on the lines it has, but
Your Honor, I thought we printed and submitted the verdict form earlier.
I think, okay, I'm sorry, you might be misunderstanding. You did, and it currently has the current parties that are sitting here in the courtroom. There's another party that hasn't submitted the order granting anything
Oh.
or
I see what you're saying.
I was trying to subtly not say it as directly as that. So
We
all
understand that.
I'm trying to say that if we still, and you can appreciate, well, the court may have to circle back with you all to see about a potential stipulation before certain documents go back to the jury. That's, the court's not telling you what to do, the court's just, I'm not sure if you all might be paying attention to your closing arguments and not thinking about that detail, so I'm just giving you a friendly.
Judge, I think from the plaintiff's perspective, we stipulate to that because I don't think we should rely on Trevor Herbst's attorneys for timing issues. So I'd stipulate that this caption can go back even if they haven't.
And the verdict form
And the verdict form.
as is submitted to the court in blue back, is that,
Yes, Your Honor.
okay? Is that what you're,
We'll agree to that, Your Honor.
okay, you appreciate why I have to ask,
Yes.
particularly from your side, I have to ask from everyone's side, but, okay, I want to make sure it was taken care of, okay, then, we'll go into the, thank you, Lord, can you please bring your.
All right, with the jury, please. Come on. Your Honor, all members of the jury are present. Jury, please, be seated.
Appreciate it, thanks so much. Welcome back, ladies and gentlemen. If you recall, we were doing closing arguments. Counsel, one of the counsels for plaintiff had done his initial closing arguments. Now we're going to turn to other counsel for plaintiffs. Feel free to commence with your closing argument. Go ahead,
Thank you,
please.
Your Honor. Thank you. Good morning, everyone.
Good morning.
We still have a little morning time left, so. My plan is, in following up after Mr. Kemp, to go maybe 30 minutes or so. We get to 12:30, then break for lunch, and then hopefully we'll finish up right after that, okay? Just to let you know there's an end in sight in terms of me and Mr. Kemp being in front of you.
Mr. Howard, do you have that microphone on?
Let me see. I know I got it attached. Being on may be another step. Let's see.
Got it.
Perfect, thank you. Oh, there we go. All right, so, ladies and gentlemen, when we started this trial, when I first met you guys, I said it up front. I said, this is going to be an opportunity for each of you individually and collectively to make a difference. I said that from the beginning. I was being honest about it. I was concerned about it because this case is a lot to consider. It's a lot to take in. It's a lot to digest. And in trying to prepare for this closing, I went over everything that Mr. Kemp went over, everything that the defendants had to say about this, everything that Real Waters Council may have said and over. And after going through everything, I've tried to reduce this closing to the highlights, so to speak, because I know you've all heard the same things. You saw the same things that we saw, you heard the testimony that we've heard as well. And you have the opportunity to determine the credibility of the witnesses you saw. It was not for us to determine for you how you accept that testimony, how much weight you attribute to it. That's for you to do. And we trust that you paid attention, we trust that you listened, and we trust that you can do this. Because I will tell you from the plaintiff standpoint, all we wanted, and it took 7 days to get this group together, get you all together with us. All we wanted was some fair-minded people who would truly and fairly listen to the evidence and come up with a decision. Because I will tell you, although you heard Real Water admit or concede liability during this trial, for over 2.5 years, that wasn't the case. And we'll get into it. But these plaintiffs have struggled to get here. There was no easy path, there was no easy road. They put in a lot of effort. They've been through depositions, they've met with experts, they've met with us, and they've been here every day for the most part. And I don't know if you ever saw a single Real Water person here the entire time. Not one. What I will also tell you is that all of the plaintiffs, and I represent in particular Ms. Sosa, who's right in the back there, and Mr. Hunwardsen, Myles, collectively with Mr. Kemp. But you've noticed, you've seen, all of the medical records demonstrate that they suffered very similar symptoms. I mean, there's nothing strange. I won't spend as much time with you as Mr. Kemp did, because he really manned the laboring oar here. He gave you a lot of information as he did in his opening, and my presentation or my closing will be shorter. Real Water doesn't dispute at this point that its product contained a toxin or poison. They don't dispute that that toxin caused the acute liver failure suffered by each one of them. But to this day, right now, right here, they're still disputing what is the value of those injuries to those plaintiffs. And what's weird to me, what's strange, no matter how long I stayed up last night preparing for this, it is so ironic that the group that caused the injury, the company that caused the injury, not only not being here, but will tell you what it's like to be in their shoes. And they're going to tell you and give you an amount, something different than the evidence that Mr. Kemp talked about in terms of Blaine Jones, and tell you why it's so much less. It's worth so much less than what Blaine said or what Mr. Kemp said. It's hard to reconcile someone causing the injury and say, oh, it wasn't that bad. In preparing for this, I've scoured quotes and books and articles about how to address when you've caused someone injury, and then you try to run away or diminish how that injury has affected that person. And it was weird because one of the quotes I found was, when someone hurts you and you don't say something, or even if you say something, they will find a way to explain how it really wasn't that bad. And that's what you will hear. And that's what you've heard in part from Real Water's expert, Dr. Alcina. And I'll get to that in a second, but I want you as a group and individually to think about how Real Water will ask you to give less money to these people than its own vice president has suggested. And how Real Water will say that Mr. Hunwardsen there, and I will tell you, I could not believe how upbeat and full of life he is. It surprised me, because it's a lot for anyone to wrap their minds around what he has to look forward to in the future. But Real Water will come with a straight face and tell you it's not that bad. Not being able to have children is not that bad. Putting your life on the line to have children is not that bad. And then after they tell you that none of that is worth it, that is not worth the amount of money, because there's nothing else our civil justice system will provide for. We can't find a baby to give him. There's no drugs that he can have a baby and not risk his own health. So there's nothing else. So after they get up and tell you it's not that bad, and it's not worth that much, then they're going to tell you, please don't punish us for putting them in that position. Please don't punish us for his situation, Ms. Brody's situation, Ms. Hartshorn's situation, Ms. Schaefer's situation, and Ms. Sosa's situation. That's what they want to tell you. And I'm giving you the big picture because that, at the end of the day, that's what it's going to boil down to. And it's just not right. There's no way I could find and reconciling the position they've taken, knowing the consequences of their actions. It's just not right. The plaintiffs, and this is something that Mr. Kemp was trying to point out, and I'll start with this. I want you to see the jury instruction 24. This is the punitive damage jury instruction. And this jury instruction tells you the conditions or the law, which the judge read to you, on punitive damages. And it says punitive or exemplary damages are to make an example of or punish wrongful conduct. We want you to make a difference because we want you to make example of real water. Real water deserves to be made an example of. Mr. Kemp gave you several reasons why. To me, in addition to all the reasons that Mr. Kemp gave you, what happens if you don't make an example of real water? What happens? And that is a problem. And I'll go further. Malice means conduct which is intended to injure a person, or despicable conduct which is engaged in with a conscious disregard of the rights or safety of others. Mr. Kemp gave you 45 minutes of examples of conscious disregard. Disregard to customer complaints, a complete disregard for your own employees getting sick, a complete disregard for your QA or lack of QA people informing you that they have no training, this place is not clean, it's not sanitary. You have inspections by third parties that tell you you're not in compliance with HACCP requirements. How much more do you need? Conscious disregard means knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to avoid these consequences. We know what the consequences are, and we know what they did which resulted in those consequences. The law in Nevada, as indicated and articulated by the court, is clear. Real water should be held responsible for punitive damages given our laws. I want you to take a look at the next slide here. This is the CDC, just the first page. I'm only going to go through a couple of pages here. But Mr. Kemp was speaking to you guys about the general type of testing that should have been done on the water, the GMCS. And you recall that. Go to the next page. CDC, of course, in their documentation talked about the typical symptoms, which we all agree to. All of these symptoms were experienced by the plaintiffs here. Go to the next. Now, this is what Mr. Kemp was talking about. This is the list of toxins that if they'd simply done this $200 test, they would have been able to weed out and assure themselves that none of these toxins was included in real water. And you can see hydrazine is in alphabetical order. Hydrazine is right there. It was one of many that they would have been able to determine was there and made different arrangements. Change the formula. Stop using hours and hours of electrical current. Change the chemicals. Simply stop. Simply stop desiring to make money at the expense of safety of others. Next slide. This is what Mr. Kemp alluded to. He showed you simply the results. These are the FDA results and the Europeans testing results. And you can see the numbers that Mr. Kemp gave you. Those are 3 FDA tests. And then those are all seven tests of bottled real water. All of them found hydrazine. 10 tests in total, not a single one didn't discover or reveal hydrazine in the water. The only thing I can think of that Mr. Odou may say, or someone from Real Water may say, is that 2 of the hydrazine levels were below the reportable limits, but they all show hydrazine. And it shouldn't be in any water, not a teaspoon, not a tablespoon, and certainly not a bottle. Go to the next. And this is Ms. Sosa. And Ms. Sosa told you her story better than I could ever tell. But the long and the short of it, and I felt horrible for her, because she was one of the few plaintiffs that, in addition to getting sick, she did everything under the sky, under the sun, to figure out what was causing it. Now, our clients, all the clients here, went to doctors to try to figure it out. But no one else went to Southwest Gas to have them test. No one hired an independent firm to check for mold. No one else bought humidifiers and FDA purifiers. No one else moved out of their home for 3 months. No one else saw their friends get sick in their homes. From the middle of October all the way through until November 3rd, she lived with these symptoms. And then after that, after being released on November 3rd, she went back home, and again, symptoms continued. They got worse, they got worse, leading her ultimately back to the hospital on November 9th. Let's take a look one more time, Shane, and Ms. Sosa's medical records. And so this is her ALT, AST scores, November 3rd, and hopefully you remember that. She got to the hospital through the assistance of her ex-husband, Dave, and her son, Alex, who she was supposed to go pick up. But after grocery shopping, she goes back to her house, she blacks out, passes out. Fortunately, Dave and Alex come to her home, they find her there, and they take her to the hospital. Her sister Nicole stays with her. She's released. And over 6 days period, she continues to decline, leading her right back. Next slide, please. Oh, there we go. So this is November 9th. She's there overnight. She's brought there nervous, anxious, nauseous, dizziness. She's suffering from the gamut of the symptomology recognized by the CDC. And she can't figure it out. Her friend takes her home, and they start trying to figure this out. She's not in her right mind. Eventually, they can't figure it out. She leaves and she moves in with a friend for 3 months, like I said before. And this takes her from roughly November all the way until we find out what's going on in March. And that's when the recall was spotted by her friend Crystal on the news. Months and months worth of suffering that could have been avoided had, like Mr. Kemp said, they stopped the line back in October when Blaine got sick on October 15th and was in the hospital. Or when Mr. Desitel said this place is unclean. Or when Mr. Anthony Randolph was telling him, I know other people in addition to you, Blaine, have gotten sick. None of that was enough. And that is the conscious disregard. You cannot allow money, profits, distribution to make your decisions for you when you're dealing with public safety. There's no way of justifying it. There just isn't. Next slide, please, Shane. Now these are Christina's symptoms. If you could, Shane. And these are almost a rinse and repeat of Ms. Brody, Ms. Hartshorn, Ms. Schaefer. They're almost indistinguishable. After Ms. Sosa got out, and again all the way through March, she's out of her house, she's not with her son. She's not doing anything she would normally do, but she gets better. Because, of course, we find out later, she's not drinking the real water. So the toxin was in the house, The problem was, it's in the form of a bottle of 5-gallon jug sitting in the house. But her son wasn't drinking it, and it never came to mind until the article was revealed about real water. Which goes back to what Mr. Kemp said right before he sat down. If they put the information out in the public before, none of these plaintiffs would have gone through those things, because it would have been out in October. Ms. Sosa, as an example, wouldn't have been in the hospital in November. She would, on November 3rd or November 9th, or spent another 3 months outside her home without her son. Same would have been true with Ms. Schaefer and Ms. Hartshorn. So I want to talk about Ms. Sosa, and I want to weave into Ms. Sosa through the verdict form, Ms. Hartshorn, Ms. Brody, and Ms. Schaefer's future medical care. That was by accident missed by Mr. Kemp. But I want to go ahead and put that in here. So if you could put the verdict form on for me, Shane, I would appreciate it. So this is the verdict form that you've seen already. Go to the next page, please. Dr. Hudson, now hopefully you guys remember this, but Dr. Hudson said the additional monitoring will be necessary. Twice a year, the liver test, you check their liver functions and liver enzymes. With Mr. Hunwardsen, I believe that both Real Water and Mr. Hunwardsen have agreed that the future medicals go all the way down. Should be future medical there. Maybe it's not in there because it's been stipulated too. We'll figure that out for you, ladies and gentlemen. Let's do Ms. Schaefer. Go up. There we go. Future medical expenses for Ms. Schaefer for her monitoring. It's roughly $1,000 per test twice a year. That's $2,000 times 20 years is $40,000. That's just for the future medical expenses. The same would be true for Ms. Hartshorn and Ms. Sosa. So it'd be $40,000 for Ms. Hartshorn. That should be above the line if you guys can make it look better. Ms. Sosa would be the same $40,000. And because Ms. Brody is a few years older, it would be $10,000. For some reason, I did not see Mr. Hunwardsen's future, but I believe that amount is $900,000, which I believe there's an agreement from Real Water on that amount. For Mr. Hunwardsen, Myles would be $900,000 future medical care because, of course, he's got a lot more to deal with. And that's agreed to by the parties. What I would also point out to you in consideration in terms of Mr. Hunwardsen, or with all of the plaintiffs, Ms. Sosa included, is Real Water will say, and I'm sure you've heard of this, hope for the best, prepare for the worst. Hope for the best, prepare for the worst. Real Water will come in, I believe, and say, perhaps based upon Dr. Alcina's statement, that these patients or plaintiffs will be fine. We believe that they will be okay. And so award them money based on the best case scenario. Ladies and gentlemen, they only get one time to come before you and ask you to make a decision in this case. If 2 months from now, Ms. Hartshorn liver scarring turns into cirrhosis and she requires a new liver, we can't come back and say, listen, we got it wrong. Her problems came a lot faster than anybody predicted. We only have one chance to come before you. She only has one chance. Ms. Sosa has one chance. Mr. Hunwardsen has one chance. Ms. Brody and Ms. Schaefer, they only have one chance, one opportunity. And this is it. And so I ask you to make a decision based upon what's more likely. And that's how Dr. Hudson said. And to make an award based upon them not having another opportunity to come before you. Because they have to prepare for the worst. And we're asking that you make a decision allowing them to be prepared for the worst. If we could you go to the Loma Linda slide? This is the Loma Linda report, and I'm not gonna go through it over again with you, ladies and gentlemen. You saw me go through it with Dr. Hudson, and if you want to, this document is an exhibit in evidence. You can look at it when you're deliberating. What's most important about it, these 4 people all drank real water, and they all, 3 out of 4, 75%, suffered scarring. And you can see it depicted in the slides. That's the biopsy results. All the blue and purple, bad. The blue coloring means scarring. And you can see that blue mixed in on several of these slides. So when Dr. Hudson said there's a more probable chance than not, that's more than just a feather on this scale. That's 75%. 3 out of 4 of these plaintiffs are likely to have suffered that issue, and 2 of these patients that had the slides had renal failure. One of the possible side effects that we talked about by Mr. Kemp. And it's all in the literature. It's all in this report, the Loma Linda report, is not a plaintiff's report. It's not a defense report. This is medicine for the benefit of medicine. There's no sides being taken here. And that's something I said, I believe, when I first introduced myself to you. I prefer to show you something that you don't have to take my word for. I'd rather show you something where no one has an axe to grind. They're simply doing it for the benefit of medicine and patients. And this is what this article provides. Next slide, please. This is Mr. Desitel. You remember Mr. Desitel. And I put this up because Mr. Desitel, to me, and this is, Mr. Kemp gave you some Desitel sites, but this comment to me just, for some reason, just resonated with me in terms of how he felt about real water. If you could play it for me, Shane.
Did you approve the way that the real water operation was run?
No, I did not.
Why not?
Violations of good manufacturing practices, GMPs. I believe in cleanliness. You got to maintain the line. You have to obtain a certain level of standard to prevent, stuff happening to the product and thus getting to the customer.
And you've worked for other companies after leaving the Army in real water?
Yes, I did.
And how does real water rate among the companies you worked for?
Last one.
And why is that?
The lack of policy, procedure, written or spoken, GMPs, FDA, any outside government agencies' requirement to maintain a manufacturing environment.
That is your supposed QC person who said he really wasn't the QC person, he was just told to be the director of quality control, explaining just how bad this place was. Now, I won't go through it. I have slides on it, but I won't go through it because I want you to get some lunch, actually. But I also know, and I feel that because of how attentive you've all been, I don't need to tell you everything. I don't need to remind you, I should say. My next point, without showing you the slides, and if you want to see them, you can always look at them because you can do so when you deliberate. There were 2 audits that Mr. Kemp spoke about, the 2018 audit and the 2017 audit. And I think we've put in front of you the 2018 audit several times because the 2018 audit says they don't have anyone who could actually put out a product, a safe product for the public. You remember that one? Now, 2017, go to the 2017 one, Shane. What I point out, you can see the date, March 2017. This says here, there is no current staff that has completed formal HACCP training. I put that out there because Mr. Kemp alluded to it earlier. He said, they're gonna say just that day someone was not there when they audited in 2018. They didn't have anyone there trained in 2017. And you know Patricia Converse, the receptionist, was not trained in 2014. I want you to consider this, and I'm gonna show you a slide a little later. All of these years, because she said there was no one before her, they don't do any tests, they do no investigations, they don't even hire someone to pretend that they have someone who's qualified to be a QC or QA person. How can you argue? How can anyone argue? I'm not taking away for how imaginative or how creative Mr. Odou is or Real Water is. But how can you argue that they cared about safety? That is, per se, a conscious disregard for the safety of others because you have no one there in your facility qualified to even determine if it's safe. Next slide, Shane. Now I'm going to give you a graph, just so you can put this into context chronologically. I asked a question of Mr. Blaine Jones, and Mr. Kemp played it, so I won't play it again, about testing from 2008 to 2020. He said there was none. The gasoline, the strong chemical smell from Ms. Stevens, Ms. Wright, Exhibit 56, May 6, 2014. The gasoline type substance, another customer complaint, May 21st. December 1st, 2016, Ms. Dorn. And I'm gonna read you, just have you listen to a short portion of Ms. Dorn. Shane?
What was the date of that email?
December 1st, 2016.
And that was addressed to whom?
Customer service at drinkrealwater.com.
And
Okay.
during that email, did you inform Real Water that you had been sick from drinking Real Water?
Yes, this is what it said. It is giving me a burning, sour feeling in my gut, and as said, diarrhea. I think you need to look into what the problem is. I will stop buying your water in the meantime. My guess is this: you're using water from the Vegas Valley, and it's hard water, which my whole life has given me diarrhea. Otherwise, something you're treating the water with or doing to it is making me sick, or the bottling is unsanitary. I just want to say I have nothing to gain from any of this. I want this to be on the record. I'm not benefiting in any way. This is taking time out of my work day, to try to help with this, but I don't have any agenda. I wanted this company to do well. I was trying to give them a heads up as a healthy person who was suddenly getting these symptoms, that they might want to be a little bit more careful about what they were doing. So I don't, this is a long time ago in the course of my life, and I'm just doing what I was supposed to do, but I don't have an agenda.
After you receive an email like that, more than one, a person sick, not only her parents, and you do nothing in 2016, let me tell you what happens. Myles started drinking the water in 2016. Ms. Brody started drinking the water in 2018. The rest of our plaintiffs, Ms. Hartshorn, Ms. Sosa, and Ms. Schaefer, they started drinking in 2020. That's what happens. I only have a few more minutes after we get back from lunch, ladies and gentlemen, but I see the time, and I'm starving. I'm assuming you each are. So I think this is a good time to break now.
Okay, I'll introduce something. Okay, 12:28 means it's 12:30, so we come back at 1:30. Ladies and gentlemen, during this lunch recess, you're admonished not to talk or converse among yourselves or with anyone else on any subject connected with the trial. You must not read, watch, or listen to any report of or commentary on the trial or any person or entity connected with the trial by any medium of information, including without limitation, social media, text, tweets, newspapers, television, internet, radio. Anything I'm not stating specifically is also included. Do not visit the scene of the events mentioned during the trial. Do not undertake any research, experimentation, or investigation. Do not do any posting or communications on any social networking sites or anywhere else. Do not do any independent research, including but not limited to internet searches. Do not form or express any opinion on any subject matter of the trial to the capability and finally submitted to you at the time of jury deliberations. With that, a very nice lunch. Thank you so very much.
All right, so the jury, please.
So council, since 2 minutes to closing, still, you all are okay to go out to lunch? Does anyone need to have access to the courtroom earlier?
No, we're fine, Your Honor.
We're good, Your Honor. Thank
Okay,
you.
no worries. Thanks very much. Have a nice lunch.
Thank you.
Hold on a second. We're now on the record, so let me just say, all counsel are present outside the presence of the jury. Counsel, just a couple of quick things before all the marshals checking on our jurors is, as you know, since you have electronic exhibits, you may have a quote clean laptop. Have all parties been able to check the laptop to make sure it's the quote clean laptop that can go back to the jury and doesn't have any proprietary opening and closing software?
Joel Odou for Water, Your Honor. I believe Mr. Zamora is checking it now, and we should have an answer shortly.
Okay, thanks. It was supplied by Plaintiffs, is that correct?
Yes, Your Honor.
Okay, so you don't have any issues there. Okay, so that's the one thing. The next thing is, we already went through all the exhibits that were admitted on Friday, and you all concurred for all of those, right? Did
Yes,
over the
ma'am.
weekend, by chance, anyone realize there was any oopses that we needed to take care of, or those all set in stone? Good, go.
I don't know where Mr. Pepperman went.
Okay, I'll pause on that question. I presume bottom line is, if you all thought there was any exhibit issues, you would have told me first thing this morning, right?
That's correct.
You wouldn't wait for the court to bring it up?
Yes, Your Honor.
Okay, so the exhibits are all set. You've got, the drives are set with the extra videos. We have the hard copy paper. I'm gonna mention a couple of them, there's a couple other ones, right? It was the amended 61 and 65. And 526 were your 3 amended paper ones. So your exhibits are taken care of. What we're just double checking, Mr. Pepperman, is that there was nothing that somebody found over the weekend, that there was anything inadvertently not considered for purposes of all the exhibits and everything we went over Friday. We good to go?
Yes, Your Honor, as far as I'm aware, I thought I confirmed last week that you received the 61, 65 paper copies.
In the purple folder by Mr. Parker, yes.
Perfect. That was the only
Okay.
question I had.
We just, sometimes people realize over the weekend, guess what we made it.
No, I
So we're just we're quadruple checking to make sure, okay. So we've got, so just so we're clear, we've got paper copy 61, 65, amended 61 and 65 with redactions, and exhibit 526, we have a collection of little hard drives, little jump drives, which are some of your video exhibits, okay? And then we have the full drives, which are all of the admitted exhibits that were put onto the appropriate data format for purposes of the jury being able to review those exhibits. So that's, and we understand that whatever laptop you're doing has the appropriate insets so that said jump drives and other data devices can actually plug into them. The reason why I mention that is, some of these days have lightning ports and things, and when people give us USBs and they have lightning ports, we just make sure that they're all compatible with your tech people, I presume. Is that, I see
We
a
have a thumbs up, Your Honor.
Mr. Godfrey's giving a thumbs up. We get a double thumbs up? A double thumbs up, all your tech people, okay. Like I said, we check some of these simple things that people, you as the attorneys aren't necessarily focusing on these things, but they get back there, so we just, we get them taken care of in advance. You already have the approved jury instructions, which were already read and signed by the court. You have the proposed verdict form, which will go back, and then we have the demonstratives. No one so far has asked us for those 2 demonstratives for your closing arguments. Remember, we do have those available, i.e. the rods and the bracket. But if not, then the clerk is going to return those either end of day today or tomorrow down to the vault with the Gallagher sticker that it already had on it. And I think that's it from our end. Once we get the laptop, and yes, I was saying things, a couple things to leave to give your side just a chance to see if they had a chance to check on the laptop, or you think it's going to take longer.
Your Honor, the laptop's ready. I was just charging it. Would you like us to produce it now?
Oh, I just want to make sure you're both signing off on it. It's okay.
We are.
It's good.
The water agrees.
Sorry, is it ready? Subject
is
to
your-
charging, is it ready to go? We don't need it right this moment. If you're charging it, you can finish charging it.
Yeah, I just noticed the battery was dying, so.
Okay. No worries, okay. So Marshall, do we have all of our jurors?
Yes, Your
Can
Honor.
you go get them while I finish up a couple little minor details?
Okay.
I appreciate it, thank you so much. Okay, so, quick follow through with regards to jury after you finish with closing. So, we normally, once we release the jury, okay, we offer the alternates the option to stay or leave. If they want to stay, we put them in the other jury deliberation room, which is between the C and D courtrooms, i.e. between Judge Williams and Judge Denton. Oftentimes people don't want to stay, but if they do, we do offer them that option so that they're not there, separate restrooms, separate everything, okay? But sometimes people want to stay and listen to the verdict. Is there something different that you all want, or does that process meet your needs?
Your Honor, Mr. Kemp is of the opinion that perhaps they should stay just to make sure nothing happens. Somebody gets sick and.
We we can't require them to stay, we can offer them the opportunity to stay and tell them that if they're going to, that they have to remain in close proximity, no less than like 20 minutes away. Generally, the process is not requiring.
Okay.
Yeah, we give them the admonishment, tell them they have to start from scratch, we go through all of that, it's just a matter of when you have alternates, sometimes people don't necessarily even want them back in the back, right, because you don't necessarily want people walking the same hall. I don't know if you got smokers or not, you got a rainy day, I don't even know if that's an issue, but, so
that's
are you
fine.
requesting that we require the alternates to stay?
No, if they're within, a certain range, 20 minutes, 30 minutes, whatever that is, we're fine with that, as long as you give them the admonishment.
We give them the admonishment so that we can let them go. My JE takes charge of them, right, and gets the phone number, the contact information, et cetera. We go through the whole, you gotta start from scratch. One of the other reasons why sometimes people don't want the alternates to stay in the other room, sometimes people have a concern of whether the alternates are gonna discuss anything. Of course, we give them the admonishment, but once again, that's up to you all. If you all are specifically requesting jointly that I require the alternates to stay, I'll require the alternates to stay.
No, we're fine.
Yeah, we're fine, Your Honor, thank you.
With the process, just letting
With
them
the
know as long as
process
they're
you
good.
described.
Okay, the next thing is, Marshall, just one quick second, is we tell the jurors that they can deliberate, that the marshal will check up on them, usually a little before the 6 o'clock hour, like around 5:30-ish, okay? If they're still here, and then we give them the option whether they want to continue to deliberate that evening, or whether they wish to, 4:30, I said 5:30, I meant to say 4:30 is what I meant to say, my apologies. Around 4:30, depending on when it goes to it, to see if they want to stay past the 5 o'clock hour, so we can just get the arrangements for overtime, et cetera. If they want to stay, we give you all a heads up. And if they're planning on coming back the following day, we tell them they can come back as early as 8:30, and we'll put them in a jury deliberation room, and I'll do them on morning calendar. And if they come to a verdict, then we interrupt the morning calendar, we take the verdict at that time. That's why we said we need to make sure we have a phone number that somebody's actually going to pick up when we do that process. The other than we tell, Mr. Counsel to stay within, we prefer 20 minutes, but maximum 30 minutes, just so in case you have juror questions, all that kind of issues. Is there anything different that's being requested? If somebody's requesting something that you all prefer, or you think should be done, let the court know.
That's fine for the plaintiff, Your Honor.
Real water agrees.
Okay.
One other thing, Your Honor,
sure,
I just want to make sure you got this, considered this in terms of timing. I said I'll be less than 15 minutes. Mr. Odou will do his thing, and then, depending on what Mr. Odou says, I may have somewhere around 10 or 15 minutes of rebuttal.
Sure, is it going to be two
Is
rebuttals
just
or
one
one
rebuttal?
rebuttal?
It's just gonna be one.
Alright.
We're gonna, one of us will do it.
Okay, whichever, no, that's perfectly fine. That's the reason I was trying to give you a ballpark of your timing issue, right? And like I said, some people don't want the jury to go past 5 o'clock. They want us to ask them to do a hard time. Most of the time, people don't. Most of the time, they want the jurors to be able to exercise their own discretion if they want to stay late, as long as it's not too late. And too late is a sliding scale depending on overtime purposes, right? Then we address that and we let you know, and if you have a hard and fast time you want us to leave, then we address that with them, okay?
Sounds great,
Just-
Your Honor. Thank you.
Thank you very much. Marshall, feel
May I
free.
sit back up here?
Oh, yeah, of course you can. Do you need,
I just gotta get the,
you going to small podium? or
Yes.
large?
I'm gonna use a large podium when we get there.
Okay, so we can turn it however you want it. Okay. Let me let Mr. Parker finish getting set up and then we can bring in the jurors, okay? Thanks so much.
Why don't I just spin this around now for you, counsel, since he's not gonna use it.
Thank you so much. Appreciate it.
You've already got, you've got a pocket microphone, so we're good. Do you want that up or down? Oh,
No.
actually, you haven't got it down right now, so Mr. Parker doesn't muffle it.
I didn't want him to.
Yeah, exactly.
But I'll fix it if you need me to.
Appreciate it.
Thank you, Marshall.
Yep.
Tested, and ready to go?
I think so. Am I okay?
No, it's not on. I'm trying to.
You know that?
Thank
Thank you.
Marshall, could you please bring him entry? Thank you so much.
Yes, certainly will. Everyone, please rise for the jury. Thank you. Come on in, folks. Your Honor, all members of the jury are present. Everyone, please be seated.
Thank you so very much, Marshall. Okay, welcome back, ladies and gentlemen. If you recall, right before the lunch break, we were in the closing arguments. Those closing arguments on behalf of plaintiffs. So, counsel, you can feel free to please continue with your closing argument. Thank you so much.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Hopefully lunch was good and you stayed dry. I gotta clean up one thing and then I'm gonna get into the end of my closing, which shouldn't take much longer, 10 or 12 minutes, I would say, and I'll hand it over to Mr. Odou. Shane, can you put up the verdict form one more time, please? So, in terms of Ms. Sosa, this is one of the, this is our plaintiff that Mr. Kemp did not discuss, and he left this to me. Ms. Sosa, I'm asking for the same amounts that Mr. Kemp suggested in terms of Ms. Hartshorn and Ms. Schaefer. Now, I'm doing it for the same reason because I do feel that we're confined to the evidence in this case. And again, the only person who's actually been through this and has put a number on it through the deposition was Mr. Blaine Jones. Now, one thing I think I talked to you about is the deposition process. When you do it under oath, and you actually have 30 days after your deposition if you want to change it. If you want to change it yes to a no or a red light to a green light, I think I spoke to you guys about this, you have that opportunity to do so. My point in saying that is Mr. Blaine Jones never changed this testimony. He had an opportunity to, and if he thought for some reason Mr. Kemp got him to say something he didn't mean, he could have changed it. If he didn't like the response, he could have changed it. If he really didn't like the response, he could have come here and got on the stand and testified under oath that that number was not the number. But he's never done such a thing to my knowledge. And he certainly didn't come here and explain that $10 million was not the right number. So that's why I use that number. The other reason I use that number for Ms. Sosa, Mr. Blaine Jones's experience with real water lasted about a week and a half. And you saw that through his deposition. Everyone here had a lot longer experience. Ms. Sosa had months of this experience. Ms. Hartshorn, walking up and down the hospital, thinking people are after her, not knowing what's going on, went through it. Ms. Schaefer went through a biopsy. Mr. Blaine Jones did not. Ms. Brody, not knowing what's going on. I mean, everyone here, I don't even want to mention what Myles went through, but everyone here went beyond a week and a half worth of symptoms. And that's why I said that number seemed to make sense, especially since he was the vice president, the son of the president of the company, who said this was the right amount. So that's why I wanted to make sure we were clear on that. All right, if you could, Shane, if you could show Exhibit 199. And I'm transitioning to this, ladies and gentlemen, because I want you to face really head on what Real Water's motivations were. It wasn't safety. Play this for me, Shane.
Transform your body with real alkalized water. Real water is so advanced, it's beyond alkalinity. Real water is alkalized antioxidant water infused with negative ions. Maximize your body and mind's performance. And with a clean and refreshing taste, no other water can compare. It's no surprise that elite athletes and Hollywood's brightest stars choose real water. So do your body a favor and get real. Drink real water. You will taste and feel this difference.
Commercial number 1. Let's take a listen to commercial number 2.
Are you feeling sluggish, old, and tired? It could be because your body is dehydrated on a cellular level. Most purified waters are acidic, and as a result, may be rejected by your body. But it doesn't have to be that way. Real water is different. It is beyond alkalinity. Real water is infused with negative ions for ultra-cellular hydration. You will immediately notice the smooth, clean taste as you start hydrating the minute it hits your mouth. Real water. You will taste and feel this difference.
Now, ladies and gentlemen, during the voir dire process, and you may remember this, there was someone who I was examining, I was talking to, who said, one of the reasons why I don't like bottled water is they claim all these health benefits. And from what I've done, research that person had performed, there were no real health benefits to this alkaline water. And I want you to think about this. Real Water was advertising, marketing, promoting its water for being beyond just hydration. It was healthy, makes you feel young, it does all these things for you, all these benefits they were talking about. And in fact, this was toxic. It was doing just the opposite. That is clear, misleading, deceptive marketing. And when they were finding out that, in fact, their marketing was wrong, they didn't change the marketing. They were doing coupons in 2020. They did these commercials for years. They never corrected them. Never. How do you know that people are getting sick from 2014, just using the ones we've shown you, all the way to 2020? You get an FDA investigation going in 2020. You don't correct your marketing material. You don't recall. You don't pull your product. You don't do anything. While the entire time saying this is the healthiest thing for you. That's what they were doing. Now let me tell you why. Could you go to slide 21, please? This is their business plan. Front page of it. Next slide, please. And this is why. The functional enhanced bottled water market was validated a few years ago when Coca-Cola purchased Glacier, which included the vitamin and smart water brands, for a significant $4.1 billion. That's why you don't do a recall. That's why you don't correct product. That's why you don't correct marketing advertisements. This is what they were looking for. This is what their goals were, their aim. That's why safety took such a backseat. Go to the next slide, Shane. Genesis, they made a deal where they were going to use or sell their 4-ounce concentrate bottles, little small bottles with just the concentrate, the ones that were tested by the FDA. And they were looking at this $100 million annual income that Genesis sales was making. Everything was about profits. Everything. You don't see a clip in there that accurately discusses all the testing we've done to make sure this product is safe. Because safety was such a distant concern when you're thinking about breaking into a $4.1 billion market or making $100 million annually. Next slide, please. They were selling it in 100 locations just in Terrible Herbs alone. They had big plans, big designs to capture this big market. And I say that to you because when you consider whether or not it's appropriate to actually indicate that Real Water should be held responsible for punitive damages, I want you to consider why they did what they did, what their motivations were. I want you to see that the money was what was guiding their decision making and why they disregarded the safety of consumers. And then I want you to consider, how do you prevent this from happening in the end? How can you do it without punitives? Because through compensatory, all you're doing is awarding money to plaintiffs who've been injured. You're not sending a message. And that's why I started my first slide with the jury instruction that the judge read to you regarding the reasons behind punitive damages. You have to send a message. You have to deter this type of conduct. And there was another way, we would have suggested it to you. If there was another way in our system, in our civil justice system of doing it, we would suggest it to you. But this is the only way. There's no other mechanism for doing it. also want you to consider Blaine Jones's GoFund letter. Hopefully you remember that. Blaine Jones said that he would not, and I'm reading this, he wouldn't wish the pain he suffered on his worst enemy. I was considering this last night, his comments, and how Myles, when he was on that stand, said he was just trying to do one thing to be better, just trying to do better. And it seemed so like polar opposites to what Blaine Jones was doing. Blaine Jones was saying just how bad it is, it's horrible for him. And here Myles is saying, I'm just trying to do better despite the position Blaine Jones and Real Water put him in. That's amazing. Some people, when they see something bad, they grab the bad and they just try to feel bad. They feel like the victim. He was doing his best not to be the victim. And I hope that Real Water doesn't get up and make him a victim again, and make Ms. Brody a victim again, Ms. Hartshorn, Ms. Schaefer, and Ms. Sosa. Because I can tell you, looking at the evidence, I hope the evidence demonstrated the same to each of you. There's only one way, in this case, for each of you, and collectively, all of you, to make a difference. And that is to make a decision in terms of compensatory that does at least what Blaine Jones says they're entitled to. And that you determine that punitive damages is the only way that each of you can make a difference and send the appropriate message. Thank you so much.
Thank you. Since plaintiff has concluded their closing arguments,
That is correct, Joe.
their initial closing arguments, we then go to defendant. Feel free to commence your closing arguments. It may take a moment to get things set up, and feel free to take the time you need to be set up.
I'm gonna try to stay close to mine. We'll see.
All right.
We'll see how that works.
If you need it, I'm going to be right here.
Thank you, sir.
You're welcome.
Would you make that shelf up, counsel?
Do you want the side shelf up is what the marshal was asking you.
No, I don't.
You
Thank
good?
you.
Okay.
I'll end up crashing into it. Trying not to make a ton of noise in front of the microphone, I did anyways. Ladies and gentlemen of the jury, good afternoon. My name is Joel Odou, again, represent Real Water. I want to thank you on behalf of Real Water, on behalf of our trial team, Mr. Love, Mr. Kaufman, who stepped out for the moment, Mr. Freeman. We really appreciate your time here today and over the last 2 weeks practically. I don't think the juries get enough credit. And what I mean by that is it's an incredible sacrifice that you make. We definitely appreciate it. All the parties appreciate it. And I'm sure the court appreciates it, and we appreciate the court and all the staff. I want to start out by kind of explaining what I'm going to talk about, explaining the process, and then I'm going to jump into things. Let me start with the process. This is my only opportunity to address you. So addressing you for the last time, possibly, I don't want to be overly dramatic about it. The way the process works is there's 2 attorneys for the plaintiffs. They get to make their opening statement first. I make my defense response, and then, as I understand it, one of the plaintiff attorneys will be doing a rebuttal, so they get 3 times to talk to you. So what I'm going to do is I'm not going to go point by point through everything the plaintiffs have argued to you. It's not a good use of your time, and you've been here for the entire trial. What I'm going to do instead is I'm going to talk about some of the evidence, I'm going to talk about some of the jury instructions, and I'm going to talk about the verdict. And I want to get this right up front and out of the way. There should not have been 1 drop of hydrazine in Real Water. That is undisputed, and it's undefensible. These plaintiffs were injured. Okay? That is also undisputed. So what we're going to be talking about is damages. And we've said that from the beginning. I'm going to say it again several times. We're not going to diminish the damages. We're going to talk to you frankly and talk to you as you deserve to be talked to directly. So what I want to start with is one of the jury instructions Mr. Zamora, could you pull up jury instruction number 12 when you have a chance, please? Mr. Zamora is wonderful, but I always throw him curveballs and ask for things. Oops, that's 12, 11, sorry. All right, 11's kind of long. Talks about the evidence that you're to consider, talks about direct and circumstantial evidence, talks about facts, that sort of thing. And let's skip down to the statements and arguments and opinions of counsel are not evidence in the case. That's a pretty important instruction from the court. So let me just say right off the bat, my statements, my arguments, my opinions, that's not evidence. Goes the same for Mr. Parker, Mr. Pepperman, Mr. Kemp. Our statements, our arguments, our opinions, that's not evidence in this case. The attorneys stipulate the existence of a fact. You must accept that fact or accept that stipulation of evidence. We have some stipulations in this case. One of the stipulations is the past medical costs of the plaintiffs. And so that won't appear on the jury verdict form, but it's something that you can consider and it's something that I'm going to talk about. Another one is the $900,000 that we agree is Mr. Hunwardsen's future medical costs. Again, it won't appear on the verdict form, but the parties agree. Now the next one is kind of interesting. Questions are not evidence. Only the answer is evidence. Now, we're going to talk about this one a little bit. You've heard how Mr. Blaine Jones was asked something to the effect of, you wouldn't go through this again if I gave you $10 million, would you? That was a question. Mr. Jones said yes. Now we're going to talk about Blaine Jones' injuries and what happened to him. We're going to go through that in some detail. I would just ask that you keep in mind that no one would rationally go through what Blaine Jones went through, what Myles Hunwardsen went through, what any of the plaintiffs went through intentionally. No one would do that. You know, they have these game shows where we'll pay you, so much money to make a fool of yourself and do these things. They don't have game shows where people get paid $10 million to hurt themselves, to take a toxin. This was an unknown toxin, and we're going to talk about that. But Mr. Jones, Blaine Jones' answer that he wouldn't go through it if you paid him $10 million, that's the correct answer. No one should have gone through this. He shouldn't have gone through it. And certainly no one should go through it over $10 million. To make an emotional response and agree with somebody that, yeah, I wouldn't go through this for $10 million is just that. That's not evidence, it's a question. Evidence is what we're going to talk about. Evidence is the actual damages that these plaintiffs suffered. And eventually, not even eventually, soon, you're going to render a verdict on what those damages should be, and we're going to talk about that. So I just wanted to get that out of the way because it felt like it was kind of hanging over us. The other thing that I feel is kind of hanging over us that I want to get out of the way before I even get into my presentation is the Blaine Jones GoFundMe video. So, Mr. Zamora, can you pull up Exhibit 19 when you get a chance? All right. So I want to go through this rather slowly because I think it's rather important. One of the jury instructions that we're going to talk about in a minute is common sense. And I think that jury instruction is very applicable to this GoFundMe video. This is the transcript from the video. And it starts right off. My name is Blaine Jones. The pain, confusion, and fear that I've learned about acute liver failure and hepatitis over the last few weeks invokes the old phrase, I wouldn't wish it on my own worst enemy. Okay. I wouldn't wish it on my own worst enemy. He doesn't know any of these plaintiffs. They're not his enemy. He wouldn't wish this on them. I think that's a fair conclusion for the jury to make in common sense. You don't wish anybody to get hurt. Nobody does. Maybe a psychopath does, but nobody does. Okay. So when Mr. Jones wrote this, this was about October 25th of 2020. This is after he got back from his camping trip. And he even says, okay, this is after COVID. We've talked about COVID, how it's touched a lot of people's lives and how the pandemic has changed the world as we know it. But let's go to what Blaine Jones says about what happened to him. Let's go to the last paragraph on this page, because I think this goes to his state of mind when he wrote this in October. The amount of work that was required of me during this whole process turned out to be disastrous. And he talks about needing money to pay bills and having to do work, and it was an impossible situation. Let's go to the first paragraph of the next page. I poured my heart, soul, blood, and sweat and tears into solving this problem. The only way I was able to keep one foot in front of the other was the glimmer at the end of the tunnel. For me, that was a camping trip. Okay, so when he got sick, he was working his tail off. He's got this dream that he's going to go on vacation, and he's going to work his tail off, and then he's going to get to have a vacation. And then let's skip ahead to the next paragraph. I set up my camp. I had everything to make this trip I dreamed of. I realized I forgot one thing back home, so I went to town to get another. During the errand, I ate at the local KFC. Ironically, Dr. Hutt, I guess, was a consultant who worked at Young Brands for KFC. Later that afternoon, I began to feel sick. Nausea came over me that night. I was not going to miss the hike my buddy and I planned for the next morning. During the hike, I broke. At that time, I did not know what or why. However, the result was a system shutdown. Okay. This is his mindset at the time. I ate a Kentucky Fried Chicken. I got sick. And he goes on and on about how he was sick and how sick he was and how horrible liver failure is. So there's no saying it's not that bad. Nobody's going to tell you that from real water, especially not Blaine Jones. We look down further. He talks about everything that he went into. He talks about going to the hospital. He talks about all the pain that he went through. He talks, he goes on and on. And if we go to page 4, about the middle of the page, we'll jump ahead, where it says, the doctor warned me, you're going to feel horrible for a few days. So that was Wednesday. And he then gets the hiccups. He feels horrible. And then when he gets home, he still feels horrible. And he gets worse when he's home. Let's go on to the next page. Second paragraph of page 5. The doctors don't know why I got sick. That's his state of mind when he wrote this in October of 2020. He doesn't know why he got sick. He doesn't think real water made him sick. He's thinking food poisoning. He's thinking overwork. He's not thinking real water made him sick. And then he talks about the next couple of days, what happened to him. And then he talks about why he needs help. And then we go to, let's see, there's one more time where he says, the doctors still don't know exactly why I contracted acute liver failure and hepatitis, as all of the common reasons were ruled out. Hepatitis A, B, C, etc. The only explanation they could give me is you worked yourself into a severe state of exhaustion. The weakest link, your liver failed. So that's Mr. Jones' state of mind on October 25th, 2020. It's not, I need to sell this company for $100 billion. The water is making me sick. I'm going to cover it up. It's, I still don't know. And if the doctors don't know, certainly it's not reasonable that Blaine Jones is going to know. And so he took out this GoFundMe page. So I think that's important context for the jury to have in considering the punitive damages. And I wanted to respond to some of the arguments made about that. So now what I'd like to do is I'd like to turn back to the things that I wanted to talk to you about if we pull up the PowerPoint work. All right, if we would go to the first slide, which is, this is the everyday common sense jury instruction. And basically the gist of it is, you all have different experiences. We asked you about your experiences in voir dire. We talked about using those life experiences to render a fair and just verdict in this case. And this is just confirmation that the law is on your side. You can render a fair and just verdict based on your common sense. You can draw reasonable inferences. You can look at the GoFundMe statements of Blaine Jones and draw reasonable inferences based on your common experience, keeping in mind that you're not going to speculate. Let's go to the next slide, please. Now, this is one of the, I don't know, they're all important instructions. It's hard for me to say the most important instruction, but all the instructions are important. But a verdict may never be influenced by sympathy, prejudice, or public opinion. Your decision should be the product of sincere judgment, sound discretion in accordance with these rules. And on behalf of Real Water, that's all we ask. When you go and look at the damages, just use your sound discretion and enter damages pursuant to your sound and sincere judgment. All right, let's go to the personal injury instruction. I think plaintiffs have made this clear. There will be damages awarded for each plaintiff in this case. And we're going to tell you, well, we've admitted that there should be damages, so that's the question, and how much those damages. And you will decide upon a sum of money for each plaintiff to fairly compensate them for the following. Okay, the next slide. The physical and mental pain, and there's no doubt, I'm not going to try, plaintiffs like to put words in our mouth and say we're going to diminish this, we're going to argue that. We're not going to do that. You'll hear from us what we're going to do. There's no doubt that the plaintiff suffered mental anguish. You've heard it from all of the plaintiffs, and we're going to ask you to put a number to that. They've suffered physical and mental pain. They've suffered loss of enjoyment of life, and some of them will experience that in the future. And again, these are things that we're going to ask you to award. Let's go to the next slide. There is no standard. There is no magic formula. There is no book that we can look up and say, you've had a liver transplant, this is what you should be awarding. You've been in the hospital for 2 weeks. You've had horrible experiences in the hospital. There's no doubt the plaintiffs had horrible experiences. There's no formula for that, okay? You just use your judgment to decide upon a reasonable amount and use your common sense, okay? Now I'd like to turn to Myles Hunwardsen's damages. All right. The court will award the past medical costs of $678,000 and change. You don't have to worry about that number, okay? The court will also award the $900,000 number. Again, that's an agreed upon number by the parties. It's a fact that's agreed upon. It doesn't appear on the jury verdict form, but it's important for you to know that that total is, about $1.6 million roughly. It's just under that. I'm not going to do the math for you, but it's just so you know that those costs are taken care of. All right, past physical, mental pain, suffering, anguish, permanent injury, loss of enjoyment of life. The number that we would recommend is different than the plaintiff's number. I don't think that's a surprise to anyone. We think $1.5 million is appropriate. The future physical and mental pain, suffering, and anguish of Mr. Hunwardsen, we think $2 million is appropriate. Now, I think the jury should give Mr. Hunwardsen a lot of credit. What he went through was horrible, and the way he recovered from it was amazing. He was back to work a month later. But I don't think you should penalize him for that. And so they've asked for his past lost earnings. That's fine. You should award him that, $178,000. That's appropriate. I think it's remarkable that somebody with a liver transplant is back to work a month later and riding motorcycles, a couple of weeks past that. So clearly, his life has been impacted. It would be foolish to say it hasn't. But clearly, he has made a remarkable recovery, and we wish him the best in his recovery. And the future lost earnings. Mr. Hunwardsen is an iron worker. He seems to love his job based on the testimony he provided. I thought his testimony was dynamic. I thought it was very interesting to hear somebody who enjoys their work and very gratifying. And if he can do that for as long as he can, that's fantastic. We think $500,000 for future loss of earnings is appropriate. Now, you've heard about his diminished life expectancy. You've heard it's possible. You've heard that we hope, and as do the plaintiff attorneys, that he lives a long and full life. But as Mr. Parker said, we don't know. Nobody knows. We don't know how much time anyone has. And for his loss of expectancy of life, we think $5 million is appropriate. So, I don't know, you add all this up, you've got 1.5 million for the past, you've got another 1.5 million, we're at 3 million, another 2 million, now we're at 5 million, another 5 million. So, you know, this all adds up to about $11 million. We think that's reasonable, but you don't take our word for it. You, the jury, decide these numbers. You've heard from the plaintiffs, you've heard from us. You don't have to pick either number. You can pick your own number. That's the way this works. Okay. Let's go to the next slide. You've heard Mr. Hunwardsen talk about his plans and hopes for the future. The evidence is quite clear that if you have a liver transplant, it's not an impediment to having children. There are proper adjustments that can be made as medication. You heard even Dr. Hudson, plaintiff's doctor, say that his medications could be adjusted. Now, Dr. Alsina was the defense doctor. In the interest of saving time, we had a statement read to you of what he would have testified had we called him to testify. But the bottom line is, if it's Mr. Hunwardsen's dream to have children, he can still pursue that dream. All right, let's go to Jasmine Schaefer. All right, again, the past medical costs are not going to be on the jury verdict. She incurred $90,000 in past medical costs. She has, there's no doubt, and we're not going to try to diminish it, that she had past physical and mental pain, suffering, anguish, permanent injury, loss of enjoyment of life from getting that biopsy. But let's talk about that biopsy, and let's talk about what plaintiff's expert Dr. Hudson said about that biopsy. And I have to change glasses, and I'll tell you what he said. Question, okay, and again, looking at the four individuals, if we were to take the four individuals here, excluding Myles Hunwardsen, and looking at the other four plaintiffs, how many of these had biopsies? Dr. Hudson, 1. Okay, and that was Ms. Schaefer. That is correct. Okay, and that biopsy came clear. There was no scarring found. Answer, no scarring found in her biopsy. Correct. Okay. So we know currently that the biopsy came out clear, as testified by the plaintiff's doctor. That doesn't diminish that she went through a biopsy. That doesn't diminish her fear of the future, of what could happen. It doesn't diminish her pain and suffering of not knowing, of being in the hospital. We think $500,000 for her past pain and suffering and $500,000 for her future pain and suffering is appropriate. That's $1 million. You know, I want to talk about future medical expenses because other than Myles, Hunwardsen, they're pretty much all the same. You'll recall that plaintiffs, Mr. Parker, I believe, argued that we don't know what the plaintiffs are going to need in the future, but Dr. Hudson recommended medical monitoring. When you go in and you get your blood test, your annual physical, they do the ALT, AST test, they test your liver function, and that's about $1,500, $2,000 a year, whatever the number comes out. We're going to err on the side of caution and say, you know what, plaintiffs say it's about $40,000, make it $50,000. That's appropriate. Whether Ms. Schaefer ever uses that $50,000 for medical monitoring, that's her business. And that's what we think is appropriate. Let's go on to Ms. Hartshorn. Ms. Hartshorn, you heard her testimony. You heard the experience that she had in the hospital. It wasn't a pleasant experience. The psychosis, the paranoia, it was awful. We're not going to diminish that. Again, we think $500,000 for past pain and suffering and mental anguish and $500,000 for future pain and suffering and mental anguish, $1 million basically, is appropriate. It's fair, it's reasonable. The plaintiffs have a different number. You're free to come up with your own number. And again, $50,000 for peace of mind for future medical monitoring for these plaintiffs, that is completely fair. And you can order, that's another number that you get to decide as the jury. You don't have to take our word for it, you don't have to take their word for it. Let's go on to Ms. Sosa. Ms. Sosa, $30,000 in past medical costs. Again, not on the verdict form, but she's going to be awarded that by the court. We think $250,000 for her pain and suffering and $250,000 for any future mental anguish is appropriate. So $500,000 total, but $250,000 and $250,000. We think that's a fair award, but again, you're not bound by what we think, you're not bound by what the plaintiffs think. It's just argument of counsel, it's not evidence. It's just to assist you in coming to a number. And again, $500,000 for, or $50,000 for future medical expenses when the plaintiffs want $40,000. That's a reasonable number in our view. Let's go on to Ms. Brody. Ms. Brody, thankfully, was not as sick as the other plaintiffs. She has $35,000 in past medical costs. We think what she went through, she described it, was terrible. She was in the beauty salon, she was throwing up, she felt faint, I'm sure provided some embarrassment as well. But $145,000 for that past mental anguish, suffering, the uncertainty, is certainly a number you could consider. And she said she's going to do the future medical monitoring. It's about $10,000. Again, I'm sorry, $7,500. She's for the future pain and suffering. She said she's doing great. She's going out with friends. They're going gambling and enjoying the things that they like. And I say, good for them. Again, I don't think you should hold that against her. It's just something to consider when coming up with future mental anguish, pain and suffering. I mean, it was a scary event. She couldn't drive. I think $145,000 is appropriate. All right, let's go to the elephant in the room, punitive damages. We suggest the answer for punitive damages is no. Now let's talk about what punitive damages are. All right, it's to punish and make an example of wrongful conduct by real water. You must find by clear and convincing evidence, in this case, that Blaine Jones was guilty of oppression, fraud, and malice in the conduct that the plaintiffs allege. You've seen for yourself in his GoFundMe that he didn't know what caused his injuries. The doctors told him they didn't know what caused his injuries. Let's go to what malice means. Conduct which is intended to injure. You must determine if Blaine Jones intended to injure people.
I'm sorry, Your Honor. Just one small correction. I want to make sure he's not.
Did I misspoke?
You said Blaine Jones instead of real water. We're not trying to. Blaine Jones is not a defendant.
Okay, so, Councilman Zach.
I'll withdraw and I'll rephrase it.
Okay, no worries.
Thank you.
Thank you, Mr. Parker.
Oh, no worries. I didn't think it was intentional.
Go ahead. Yeah, no worries. Council.
Real water. Mr. Parker is absolutely correct. Did real water engage in despicable conduct with a conscious disregard of the safety and rights of others? We're going to talk about this a lot. Well, not a lot. I don't intend to keep you very long, but we're going to talk about this further. Oppression. Despicable conduct that subjects a person to cruel and unjust hardship with a conscious disregard of the rights of that person. Fraud. Intentional misrepresentation, deception, concealment of a material fact. Before the FDA discovered hydrazine was in the water, Brent Jones had never heard of hydrazine. John Marlowe, the inventor of real water, had never heard of hydrazine. Blaine Jones, who made the concentrate, had never heard of hydrazine. Let's go to conscious disregard. Knowledge of the probable harmful consequences of a wrongful act and a willful and deliberate failure to avoid these consequences. All right, so what is the jury charged with doing? Let's go to the next one. You get to decide if real water engaged in wrongful conduct warranting the award of punitive damages. And plaintiff's counsel, Mr. Kemp, had a number of points that he made. I'm going to address them one by one. But if you decide to award it if punitive damage is justified, you would check the box and there will be further proceedings. Let's talk about, before we look at the evidence, let's talk about clear and convincing proof. Mr. Parker, I believe, said this, but just to touch on it again, it's a firm belief or conviction as the allegations sought to be established. It's a degree more than mere preponderance, so more than that feather that we've talked about, but less than beyond a reasonable doubt, less than a criminal standard. Proof by clear and convincing evidence is proof which persuades you of the truth of the contentions is highly likely. Okay? So let's talk about hydrazine because that is the issue in the case. Real water tested. We're going to look at some of the tests they performed. They tested when they started the company. They tested as the company ran frequently. Mr. Jones testified what Silver State Analytical did. They tested the product, the bottled water, the finished product. They tested it weekly, quarterly, yearly, and a comprehensive test every 4 years. You may say to yourself, well, why did they discover hydrazine? Because no one thought to test for hydrazine. It wasn't something expected in the water. Okay? You don't have to take my word for it. We'll get to that in a minute. Let's talk about what Blaine Jones further testified. Let's talk about the audit, and we'll come back to hydrazine in a minute. Blaine Jones testified that he knew there was a failure of the audit. That was in 2019. Okay? And then after they failed the audit, go to the next slide, they had a re-audit. And Blaine Jones himself went through HACCP training. All right, let's go to the next slide. And he testified, somebody had had HACCP training for 4 to 5 years over the production areas, quality control. She resigned her position a few days prior to the audit. It's actually a surprise audit. She resigned within a week of the audit when the auditor showed up, so it was a bit of surprise at the time, and unfortunately, I had to kind of step in and, do the best that I could. And then he got HACCP training. So, as you'll recall, Dr. Hutt paid $700 an hour or something like that, only testified about the failed audit. Let's go to the next slide. We had to show her on cross-examination the re-audit and the fact that there was a re-audit. For reasons that the jury can draw its own conclusions, she didn't testify on direct as to the re-audit. Let's go to the next slide. Let's focus in on each of these line items because the plaintiffs have made an issue out of the re-audit. Can we zoom in on the first couple of them, Mr. Zamora? All right, we cannot zoom in on them, but if you'll see, the answer in the right-hand column is all yes. Every single thing that Real Water failed at, they passed in the re-audit. So this claim that Real Water, was out of control were the words that she used. You've got to look at the actual evidence. And the actual evidence is they failed the audit, they fixed the problems, they had a re-audit in 2019. Now, Jeffrey Dussatel, he worked at Real Water in 2017. So what does he have to do with this? Nothing. All right, let's go to the hydrazine question before we go into some other points. All right, Charles Nisland is the person who testified for Eurofin's laboratory, the laboratory that discovered the hydrazine. He was asked point blank, is it standard? Let me just say it this way. I think I've touched on this one in response to Mr. Kemp's last question, or second to last question, but as far as you're aware, is hydrazine an analyte that is typically tested for in standard bottled water testing? His answer, to my knowledge, no, it is not. And is hydrazine something that's tested for in any sort of standard water testing you're aware of, such as municipal or anything like that? To my knowledge, it is not. In fact, you described that Eurofins had to develop a special protocol to even test for hydrazine. Yes, that is correct. So let's talk further about hydrazine. Dr. Najim came and took the stand. Dr. Najim cannot even tell you how hydrazine got into the water. He can tell you 2 theories how it probably got in the water. That's the best that Dr. Najim, who studied this issue, can do. But the plaintiffs would like you to believe that Real Water should have known that hydrazine was in the water. Now let's talk about the FDA. The FDA took a sample of Real Water in March of 2021. It took them till October of 2021 to return a test that they found the hydrazine. Now I want to talk a little bit about some of the other so-called notice complaints that we've seen. Let me pull up. All right, let's take them in chronological order. Mr. Zamora, do you have Exhibit 61? All right. Lime ginger is Susan Doran. This is her complaint. And I think it's very important for the jury to look at the actual evidence rather than the arguments of counsel. If we look at the last sentence, my guess is this: you're using water from the Las Vegas Valley and it is hard water, which my whole life has given me diarrhea. Otherwise, it's something you're treating the water with or doing it that is making me sick, or the bottle is unsanitary. This is in 2016. So Real Water filters the Las Vegas Valley water. They filter it about 7 different ways. They check to see if their bottles are unsanitary. We've seen the Silver State analytical tests, weekly, quarterly, monthly, yearly, every 10 years, annually, whatever it is. We've heard Blaine Jones' testimony to that. So to say that this puts Real Water on notice that there's hydrazine in the water is something that we would suggest the jury should reject. Let's look at Exhibit 56, please. Again, this was another exhibit that Dr. Hutt attempted to testify very quickly to and didn't like the response of Real Water to the complaint. Customer turned in a 1 liter bottle purchased at Las Vegas at a Chevron on, looks like Spencer and St. Rose, manufacturer 417-14-2. There was a strong chemical smell in the bottle with a TDS reading of 26. We went and purchased several other bottles from the gas station in that area with the same manufacturer, all of which tested around 19 TDS, meaning Real Water tested it to see if it was within their standards, and it smelled fine. It is inconclusive if the customer complaint was legitimate or not. This issue is closed. But then, let's scroll down further. There's an asterisk at the bottom of the page that Ms. Hutt didn't inform the jury. We also tested the control sample from the manufacturing date and found no problem. It's a shame that Ms. Hutt left that out. Let's go to 57. Customer said she found let's see, make sure we get this whole thing, a gas-like substance in a something liter bottle purchased at a Chevron in St. Rose, Maryland. A similar report happened a few weeks prior from the Chevron on St. Rose, Spencer. Customer's mom dropped off the bottle, manufacturing date 4/17/14-2, the same shift as the previous report. I went to both Chevrons and bought some bottles, including one from the same manufacturer date. Store personnel said that no problems about water taste have been reported to them. We then tested the pH, the ORP, the TDS in the store-bought bottles, and the control bottle from the date of the manufacturer. There were no problems indicating a gas-like substance in any of the bottles. The results are once again inconclusive, like in the report, a fax a few weeks ago. Customer's mom was given a free case of water when she's dropped the bottle off. We are considering the matter closed. So Dr. Hutt criticizes Real Water for not investigating these complaints and then doesn't even read to the end of the page. All right, let's talk about Mr. Watkins. Now, again, plaintiff showed you the email from Mr. Watkins. It's exhibit 71, if you can pull it up. Now, actually, Mr. Zamora, can we go to the end? We'll read up from the bottom. So let's see, the first email, emails are always confusing because you got to look at the times to see which one was first. So the first email appears to be sent around 3:42. So as you can see, there's an ongoing communication between the Watkins and Real Water. Is this communication over Mr. Watkins being in the hospital? No, it's a dispute. It's a silly dispute about getting a refund for the cooler. Plaintiffs want you to draw the conclusion that, oh, well, this puts Real Water on notice that there's hydrazine in the water, when in reality, this puts Real Water on notice that they've got a customer service problem and they shouldn't be charging somebody for a cooler rental. And then we scroll down and she says, I'm not trying to get anything for free. I feel like I had to defend myself. I'm just trying to clear up my bill. I've even come to talk with Amy. So you can see the customer is pretty upset. And then she concludes with, my husband has been in the hospital for 2 weeks and the doctors want him to stop drinking alkaline water. Not stop drinking real water, stop drinking alkaline water. And she can provide the information to see if they're lying about it as well. She doesn't need this BS. So again, does this put Real Water on notice of hydrazine? We would suggest your common sense will tell you no. Now I want to conclude with a couple of last points. I gotta keep changing glasses to see. Now, we've heard in an argument that the water was electrified for a long time. Well, that only just goes to Dr. Najim's theory that he has two possible theories, and he doesn't know which it was. He never heard of nitrogen from room air dissolving into water and then turning into hydrazine. So not even Dr. Najim expected to find hydrazine in the water. So all of this is a really long-winded way of saying we would suggest that you check the box no for punitive damages. We would suggest that there is no dispute that the plaintiffs were injured by Real Water. There is no dispute that they should recover their past medical specials, that Mr. Hunwardsen should be awarded his $900,000 for future medical specials, and that the jury should exercise calm and reasonable judgment in awarding all of the other damages on the jury verdict form. Again, thank you so much for being so attentive and for participating in the jury service process. We very much appreciate it.